Welcome and thank you for tuning in to yet another one of our videos where we try and educate you about intellectual property and everything involved in intellectual property, including commercialization. So this month we're going to focus on Africa because, as we know, in May we have Africa Month, and this is because the African Union was formed on the 23rd of May. And as a commemoration of this unity of African countries, we're going to be talking all things innovation in Africa and talking to entrepreneurs and how they find the innovation or intellectual property protection system in Africa and how it works for them. So today we're going to be chatting to Moses Nkomo. He's going to be telling us more about the ARIPO system. And what ARIPO is, well, Moses will explain to us, but I just wanted to reiterate the fact that intellectual property rights are territorial rights. So if you want protection in South Africa, you have to apply for protection in South Africa. If you want protection in Mexico, you have to file for protection in Mexico. In Africa, though, we have two regional intellectual property offices, namely the African Regional Intellectual Property Organization, ARIPO for short, and the Organization Africaine de la Propriété Intellectuelle, which is OAPI. So how these were initially divided was that ARIPO was for English-speaking countries and OAPI was for Francophone countries. But things have changed a bit. Moses will correct me if I'm wrong. I know that ARIPO does accept member states from non-English speaking countries. So Moses, please tell us more about ARIPO and what it is. But before we get to ARIPO, please tell us about yourself. And I just want to say thank you for giving us your time to chat to us today and to educate us more about intellectual property protection systems in Africa.
Thank you very much. So it's a pleasure to be part of this conversation, and happy Africa Month to all your viewers. I'm a Pan-African. That's what I pride myself of being. I believe in the potential that Africa has. So the name has been given. Moses Nkomo is my name. I am a registered attorney in Zimbabwe. I've been in practice since 2002. So this is my 19th year of practice. I've been practicing intellectual property law since 2005. I've also been lecturing in intellectual property at the University of Zimbabwe. I also lectured for a short period in the Masters in Intellectual Property program that is offered by Africa University in conjunction with ARIPO and WIPO. Mm-hmm. I am a consultant with a company called IPIQ Business Solutions, which I established in 2012, which provides strategic intellectual property interventions for entrepreneurs and innovators in Zimbabwe at the present moment. But we have a Pan-African vision for that project. Educationally, I have a Bachelor of Laws from the University of Zimbabwe, a Master's in Intellectual Property from the Africa University, which was sponsored by WIPO and ARIPO, an Executive Master's in Business Administration from Africa University. Currently, I am doing my Doctor of Laws degree in Intellectual Property with the University of South Africa.
Oh, wow.
So briefly, that's who I am, yeah.
Okay. Well, thank you for that brief intro into who you are. You are very passionate about intellectual property, clearly. So I think we're speaking to the right person. So Moses, let's get right into it. Can you please explain to us what ARIPO is? What is ARIPO and how does this intellectual property protection system work?
All right, so you mentioned in your opening remarks what ARIPO essentially is. It is an intergovernmental organization that was formed in the late 1970s through what is known as the Lusaka Agreement for the establishment of the African Regional Industrial Property Organization, as it was called at the beginning. It, like you correctly pointed out, initially it focused on English-speaking African countries, mainly from Southern Africa and East Africa. But it then had a few members from West Africa. You're talking of Ghana, you're talking of Liberia, you're talking of Sierra Leone as well. Those were members that were from West Africa, but initially it was predominantly English-speaking African countries. That was because it was formed approximately at the same time with OAPI, and the agreement was, let's have a Francophone and Anglophone organization, because these were the two main colonial masters on the continent. And it covered quite a significant part of the English-speaking African countries, particularly in Southern Africa and East Africa. The organization has its headquarters in Harare, Zimbabwe, since its inception in I think the office in Harare was opened in 1982, and it has grown from very few members at its inception to currently 20 members. It administers a number of protocols covering different aspects of intellectual property. So there is the Harare Protocol for the registration of patents and industrial designs. Then there is the Banjul Protocol for the protection of trademarks under the framework of the African Regional Intellectual Property Organization. Then you have the Swakopmund Protocol that was concluded in 2007 for the protection of traditional knowledge and traditional cultural expressions under the auspices of ARIPO. Then you have this, the Arusha Protocol for the protection of new varieties of plants that was adopted in Arusha, Tanzania in 2015.
Okay.
It also has a very active copyright mandate, but there is no protocol on copyright at the present moment, but it has a very active copyright mandate, and it's been involved in a voluntary system for registration of copyright under the ARIPO auspices as well. So that is what it is. And you correctly pointed out, presently it is no longer Anglophone or restricted to English-speaking African countries.
Yes.
You have Portuguese-speaking countries like Mozambique. It's part of ARIPO. You also have Sao Tome and Principe. That's another Portuguese-speaking country as well. So it is now opening up, or should I say, member countries or potential member countries are realizing that, after all, it's not for English-speaking African countries. Any country in Africa that wants to use this system is permitted to join the system. Maybe I should just dive into how does a country join. So a country subscribes to the Lusaka Agreement. That's the first step. You subscribe to the Lusaka Agreement, which establishes ARIPO and sets out its mandate and its parameters of operation.
Okay.
Then the countries will then choose which protocols they want to accede to. So if a country is interested in trademarks, they will have to accede to the Banjul Protocol on the registration of trademarks. They deposit an instrument of accession, and once it is accepted, a period of 3 months is allowed before the country can actually begin to be designated by potential interested parties.
3 months.
Yeah, it's just a period of 3 months. I should also mention that ARIPO has of late been very proactive in communicating its value proposition to not only member countries, but also to creators and users of intellectual property in the member countries and beyond.
Okay.
So what used to be an obscure organization has now taken quite a center stage on the development of IP on the African continent. And it has worked in collaboration with the World Intellectual Property Organization. One of the biggest things that they've achieved in the recent times is the Masters in Intellectual Property degree that they co-sponsor with ARIPO.
Okay.
At the present moment, the degree is run in 3 ARIPO member states. That's Zimbabwe at Africa University, that's Ghana, and in Tanzania. And ARIPO has played a very significant role in that regard. It has enhanced human resource capacity building because the program takes government employees, people that work in national IP offices, people that work in national educational institutions and other government departments, as well as lawyers that are in private practice. So it has played a very significant role in raising the skills level of African IP practitioners, both at an administrative level and at a practical level.
That's very encouraging. So I just wanted to ask, so now back to how the ARIPO filing system works. So if I file my application through ARIPO, I believe that ARIPO is an examining regional office, right? So how does that work? Like, what do they look for in the examination? Like when you submit your application?
So ARIPO is a hybrid system. I would not call it an examining system as such, because ARIPO does not give substantive rights. What ARIPO does, when you make an application through ARIPO, you file one application in one language, you pay one set of fees, and you file through one office. Okay? So you then designate the member countries where you are interested in. To help the member countries, the ARIPO office then conducts, firstly, formal examination to see whether you have ticked the right boxes, you have paid the right fees, and you've done all the necessary things that make your application acceptable. Then ARIPO does for patents, for example, they do substantive examination because most of the member countries lack capacity to do substantive examination. Okay. So they conduct substantive examination on behalf of the member states. But ultimately, the application is then forwarded to the member countries for purposes of substantive examination in terms of the national legislation of the particular country. So if you designate Zimbabwe, the substantive examination has to comply with the provisions of the Zimbabwean Patents Act, because what you get through ARIPO is a bundle of national rights. It's distinct from OAPI, where you get a regional patent, if it is a patent, or a regional trademark, if it is a trademark.
All right.
In ARIPO, you get a bundle of national rights. So if, for example, in Zimbabwe, your application for a trademark is deemed not to be registrable, Zimbabwe is allowed under the Banjul Protocol to notify ARIPO that this trademark will not be protected in Zimbabwe, and they give their reasons, because it does not comply with the national legislation. So ARIPO is a filing system, not strictly speaking an examining system. The examination is done to assist its member states, some of which do not have capacity to do substantive examination, especially of technical subjects like patents.
All right. And then I just want to find out then, in terms of the designation, can you just like flesh out what that involves, and also how you would advise a client when they say, I'm filing through ARIPO, which countries should I designate?
Okay, so the designation system follows what I said earlier on, that ARIPO is a filing system.
Mm-hmm.
What you are doing, you file your application, but the actual protection comes from the designated countries. Okay, so you pick and choose the territories where you think you need protection. And that for me is a business decision. You're looking at where there is a risk of infringement, or where you want to gain market exclusivity. And you say, okay, Zimbabwe is a potential market, Tanzania is a potential market, Namibia is a potential market, Botswana is a potential market. Then you say, I want to be protected in country 1, 2, 3, and 4. Unlike just choosing some countries where your goods may not even be marketed. So I was saying designation is a business decision where you're looking at the market and where you want to gain exclusivity. So some of our economies in Africa are very small. So you may not need to invest a lot of resources in designating small states. I will not mention any small economies lest I be misunderstood. But I guess you understand what I'm saying. So you're looking at the size of the economy and the potential that your product has in a particular market, and you then want to seek protection in that. Many people think you just need to tick all the boxes. That is a wrong decision. The protection must be linked to the market potential. At least that's what I advise my clients.
Okay.
You look at the market potential and you then seek protection where there is significant risk of your business being affected by infringement.
Okay, thank you very much for that. And then I wanted to ask now then, what are the advantages and disadvantages of filing through ARIPO?
So there are many advantages for filing through ARIPO. The first advantage is that it is a cost-effective system. I'll give you an example. So to file a national application in Zimbabwe, if you're a foreign applicant, you pay for the application fees, you pay US $200. And that's for Zimbabwe only. If you pay through ARIPO, the application fee is 100 USD, and you are designating. You then need to pay designation fees for each country, which is $50 per designated state. So let's say you want to file in Zimbabwe through ARIPO. You pay a maximum of $150 because you pay the $100 for the application fee and the $50 for the designation fee. So that gives you a cost advantage when you file through ARIPO. And when you file in many designated states, it becomes even more cheaper. So that's advantage number one. Advantage number two is that you don't have to file multiple applications in different jurisdictions. You file one application, you use one agent, and you file in one language. We said earlier on that there are now non-English speaking countries that are part of ARIPO. You don't need a translation into Portuguese if you're filing through ARIPO, whether it's a patent or it's a trademark. You just file in one language, which is English, and it is transmitted to the member state, notwithstanding that it may have a different language. Then the third advantage is that it's efficient. You don't need multiple agents in multiple jurisdictions. One agent in one jurisdiction can represent you in respect of all the applications. At least for the application stage, one agent can do everything for you. Then the fourth advantage is that, like I said, the ARIPO system is very useful in assisting its member states, which do not have capacity. So you are assured that if you're granted an ARIPO patent, it's a properly examined patent because the examination is done by ARIPO. And ARIPO uses international search authorities that are used by everybody else.
Okay.
So the quality of rights that you get is very high. So those are the advantages of using the ARIPO system. Again, it gives you the opportunity to transform a national application, an ARIPO application into a national application, retaining the priority date of the application that would be filed at ARIPO. So it is a flexible system that allows you to use. One major disadvantage that has been spoken about is that the rights being national rights or being territorial, there are questions over enforceability of certain rights that ARIPO grants. Okay. I will give you an example of trademarks.
Yeah.
For trademarks, you have 10 member states that are party to the Banjul Protocol.
Mm-hmm.
Of those member states, the majority of them do not have national registration that recognizes trademarks that are registered at ARIPO.
Wow.
They don't speak specifically to recognition of marks that are registered at ARIPO. Right now, we have 5 member states that specifically recognize that: Zimbabwe, Namibia, Uganda, Malawi, and which is the 5th country? Is it Tanzania? That specifically recognize ARIPO member states. So people then question the status of ARIPO registered rights, especially where there is default registration, because when ARIPO transmits an application to a member state, they are given 3 months within which to indicate whether this mark will be accepted or it will not be accepted in a particular territory. If there is no response, then it is deemed to have been accepted. Okay. So that aspect of deeming applications to have been accepted, where there is no specific provision for the recognition of ARIPO trademarks, creates uncertainty as to the enforceability of the rights that are given through the ARIPO system. So that's the major disadvantage that is there. But I should say, from my interactions with the ARIPO office itself and other stakeholders, it's a process that is being addressed. A process has been undertaken for member countries to take a position whether they will recognize and protect or they will not recognize and protect. So we're expecting in the next few years to see some clarity and certainty in that respect. Okay.
So that's that one major disadvantage. So there are more advantages than disadvantages to file through ARIPO. I know that South Africa isn't part of ARIPO or OAPI, but I think it's a big advantage in terms of the other countries that are member states to ARIPO and OAPI, that it covers like 65% of the African territories. So that is like a very wide net for ARIPO and OAPI. I wanted to ask you just one thing though. How long do you have as an innovator to file or to designate a country? Say I've filed my application through ARIPO today for patent protection. How long do I have before deciding which countries to designate?
So you are given, I think, up to 6 months.
Okay.
From the date of filing, where you can file additional designations, or you can make additional designations to the other interesting markets if you have discovered such. Mm-hmm. And that's part of the flexibility that I was talking about. Both the Harare Protocol and the Banjul Protocol allow for later designations. I don't have the exact timeline, but I think it's about 6 months from the date of initial filing, within which you can make additional designations of member states.
Okay, excellent. And then Moses, now let's bring it closer to home. You're based in Zimbabwe. So I wanted to know what percentage of the ARIPO filings are from Zimbabwean citizens? And also if you can just tell us which countries file the most via ARIPO.
So it depends on what type of intellectual property rights you're talking about. For patents and utility models and industrial designs, I think the highest number comes out of Kenya. And you'd understand that Kenya is emerging as a powerhouse in East Africa. There's a lot of innovation and invention that is taking place over that side. So for patents and trademarks, I think for patents and industrial designs, you have Kenya as the top user of the ARIPO system of the member states. Then Zimbabwe takes, I would say, between 25 and 30% of the trademarks that are filed from ARIPO member states. But while we're still at that, you'd find that most of the designations or most of the applications, they actually originate from countries that are outside Africa. So you're looking at applications that come out of Europe, out of the US, out of China, but of the member states, in terms of patents and designs, it's Kenya. On designs, Zimbabwe comes number 2. Then on trademarks, it's Zimbabwe, I think, because the ARIPO office is in Zimbabwe. A lot of our people here are aware of its existence and the opportunity that it gives to get into the market. So those are the figures as I have them. Okay.
So you've broken it down for me then. So in terms of patents and utility models, so Zimbabweans are not filing the majority of applications. It's Kenya, if I understand correctly. Okay, well, we have connectivity issues, so we've lost connection with Moses there, but he has answered a lot of the questions that we had for him in terms of ARIPO. I hope that this has been a very informative video. And if you require any information, please don't hesitate to contact DNM Attorneys, and then they will assist you with all your intellectual property protection requirements. Thank you.